Hi there, welcome everybody. So joining us today, we have Anna Bennett, who's a partner at Devonshire's. She's been an expert in all related housing matters and is going to offer us a deep dive into the coming changes with the rental reform white paper and hopefully soon to be bill. So without further ado, I'll pass over to Anna, who can kickstart our webinar. There will be a Q&A session at the end, so I'll be keeping your questions for that session. And please do put them in the Q&A, or at the end we can take some questions with the virtual roving mics. So without further ado, I'll hand over to Anna. Thank you.
Thanks, Theo. Thank you so much. Yes, so I'm here to talk to you about your masterclass. I'm hoping it'll live up to the name of a masterclass. We're going to talk about the white paper renters reform. Yes, I am a partner at Devonshire Solicitors. We mainly work for registered providers, so a lot of what's mentioned in the white paper, which may be quite novel for private landlords, we kind of do as a matter of course. So grounds, for example, grounds for possession, you quite often go on grounds because Section 21 isn't really so readily available to our clients. Also things like rent increase notices, Section 13, is not really unfamiliar ground to us, albeit the changes will impact social landlords also. But this session's focusing on you as private landlords and what it means for you. So the structure of session today, I'm going to talk about, basically I'm going to jog through the white paper and what is proposed. And I'm sure, well, I mean, nothing more has happened, I don't think, on this since it was announced by Michael Gove. We don't have any implementation date. There's nothing was announced at all, absolute radio silence at the Conservative Party conference. So I would suggest that the early signs that they wanted to push this ahead and push it through as quickly as possible have probably come to a bit of a halt at the moment with the changes in government, which all happened about a week after Michael Gove announced the white paper, so slightly unfortunate timing. But we know what's coming, and I think what's important to remember is there's quite a lot of political will behind this. So Section 21 has been talked about for a long time, the abolition of Section 21 no-fault grounds. Contractual rent review clauses, not really mentioned at all in the consultation, but obviously a lovely big surprise for everybody, and that could potentially have a massive impact for lots of, not just private landlords, but also my clients, social landlords, as they do rely on contractual rent review clauses a little bit, which I don't think is being taken into consideration. So there's a lot in there. There's, and then we're going to talk today, so we're going to talk about the grounds, what that means, the differences to the tenancy agreements as proposed at the moment, so far as we can glean from the detail provided. We're also then going to briefly touch on decent home standards, other proposals as well. So what a private rented ombudsman would mean, the property portal, and so on. And there's also, I've taken it off the index, but I'm going to briefly touch on court reform, so possession claims, and what is proposed there. The answer is not very much, but I will come on to talk about it. So probably the most headlining thing is the removal of Section 21 and the proposed new grounds for possession. And the rationale behind this is pretty clear. They're quite committed to abolishing Section 21 no-fault grounds. They want landlords to have to prove their case for possession. They don't want tenants to have that, you know, potential insecurity created by the thought that actually as soon as a Section 21 notice is served, then potentially they can be turfed out. Obviously, in reality, we all know if you have to seek possession, it's never that quick as a 2 months notice. But even so, the idea is that everything should be covered by the grounds for possession. The government is trying to allay some concerns by introducing new mandatory grounds, additional mandatory grounds for both private landlords and the social sector. And there are also further changes in terms of saying notice periods have to be more proportionate, basically giving tenants a longer period to actually hopefully move out when the notice is served rather than being 2 weeks, for example, for rent grounds, being 4 weeks, and so on. So I'm going to just quickly skip through the new proposed grounds as far as we can see them. And this, you won't find this in the white paper itself, but you will find this in a document called a new deal for renting, and it's the government response, and that's got quite a lot of it's got detail in it. It's got an appendix in it which basically goes through all the grounds, so it's worth having a read of that if you want to prepare yourselves. But essentially there's new grounds for moving into a property or selling a property. They're both mandatory grounds. You have to give 2 months notice. There is a caveat. So at the moment, the way it's proposed is that you can't then market and relet the property for 3 months following the ground being used. It's not clear what they mean by the ground being used, i.e. after the notice is served, is that 3-month period, or if you have to go for possession, is it after you get the possession order? So there's a lot of detail that needs ironing out. But, and also the other thing that's not clear is who's going to monitor that. Is that are they going to be relying on your former tenant watching the property and watching Rightmove to see if you've actually then marketed the property? But those will be those 2 grounds. The demolishing substantial redevelopment grounds, 2 months again a mandatory ground if you want to basically pull down your property or substantially renovate it, then that gives you a mandatory ground so long as you give the 2 months notice. Mortgage lender, that gives the mortgage all the right to seek possession. Not on the slides, but I did just note it as I was reading through again the New Deal consultation document. They are going to be removing ground 3, which currently exists for properties which may be holiday lets. So it sounds like a ground which probably isn't used very often, but that formerly gave landlords the right to seek possession where property was used as a holiday let. So they're removing that. They're trying to move away from that kind of temporary nature of accommodation, that more properties should be available to more permanent tenants. Other grounds, this isn't actually a new ground. Ground 9 is suitable alternative accommodation is available to those who need it. There are some new elements in it, but they don't apply for private landlords. This is discretionary. You have to give 2 months notice. This would be where you proposed an alternative property for your tenant for whatever reason. So there is a mandatory ground now for criminal and severe antisocial behaviour. This is quite interesting the way they phrase this, because at the moment you've got ground 14, which means you can serve notice wherever someone's causing nuisance and annoyance or they're convicted of an indictable offence. Indictable offence being basically something you can be sent to prison for. So at the moment with ground 14, you can serve notice and then issue proceedings the same day. The way that they've worded this, they've said it's mandatory. You have to give 2 weeks notice, but you can actually issue proceedings the same day. So it's slightly, I don't really understand the reasoning behind it. I guess it's giving your tenants a clear date to move by, being 2 weeks later, but it doesn't stop you issuing the proceedings on the basis, I assume, that actually it's going to take you at least 2 weeks to get a notice of hearing back anyway. Now, this is the next ground is repeated arrears. And this is now going to be a mandatory ground. This is probably quite welcome. Under the current grounds for possession, when I talk about grounds for possession, I probably should have said at the start, you can find everything under Schedule 2 of the Housing Act 1988. That will set out all of the grounds that you can currently rely on. So that is worth knowing about in any case, if you did want to use proceedings other than Section 21. Have a little practice run perhaps, but they're proposing a new ground for repeated arrears. So at the moment there's ground 8, so where someone is in arrears over 2 months, if it's a monthly or weekly tenancy, if they're over arrears 2 months, then at the date of possession they're still in arrears of that amount, then you should get possession on the mandatory grounds on ground 8. That can be defeated by tenants paying in at the last moment to bring it below that 8 weeks or 2 months arrears. So they are saying, the government is saying, where someone is in over 2 months of rent arrears at least 3 times in 3 years, then you can serve ground to seek possession with 4 weeks notice on that new mandatory ground. So it's repeated serious arrears, and it should hopefully avoid that sort of last minute payments, the tenant suddenly finding a couple of grand behind the sofa to pay off those arrears below a certain level. There's other new grounds which are going to be introduced, such as if you employ somebody and you let your property out with an AST, then that gives you 2 months notice. Quite often with employment contracts, they tend to be done under license. So it's worth maybe speaking to solicitors if you have that kind of relationship anyway as to what's appropriate there. Now, the will intestacy grounds exist already, but what the government's saying is actually they give you 24 months, so 2 years notice to seek possession after the death of a tenant, because you are hopefully aware that obviously with a tenancy agreement, it doesn't automatically terminate on somebody's death. You do need to take steps to end it. It's usually serving a notice to quit on them and on the public trustees to confirm that the estate's ended. But basically it will carry on that tenancy in the name of the estate until it's relinquished up by the estate. And where you have someone who's staying there and they're saying they inherited the tenancy, it probably doesn't come up that often for you, but it does sometimes. Anyway, there is the ground 7 currently is going to be expanded slightly to make it a bit easier for landlords to seek possession on those grounds, and that'll be mandatory. There's current grounds on right to rent. What's interesting with this one is for right to rent is actually the courts, they're saying the court can then order that the tenant affected who has been found to not have the right to rent in this country, their tenancy can be moved on to another tenant or another occupier from the disqualified tenants as an alternative to seeking possession, which could be a much more satisfactory answer all round. Nuisance and annoyance, there's discretionary grounds to back up the mandatory grounds. Again, it's 2 weeks, but again, this slightly strangely worded way that they're saying you have to give 2 weeks notice, but you can issue in the courts immediately. So it does kind of give a bit of a nonsense for those grounds as what the expiry date on a notice actually means, but there you go. So essentially, you're going to have to be giving 2 months notice on these grounds where it's circumstances outside the tenant's control, i.e. you're looking to sell the property, move in yourselves. Where it's rent arrears, it's going to be 4 weeks. More serious breaches, 2 weeks. ASB, essentially it's immediate, but you do have to put 2 weeks notice period in, but you can still issue straight away. So those, in a nutshell, are what the proposed notice periods in accordance with the white paper would be, and slightly more than existing. So what does this mean? Well, it's quite a big thing for private landlords. If the no fault eviction goes, if you can't serve Section 21, you can't rely on Section 21 notices. Essentially, that means there will be no more accelerated possession proceedings, which is where, so long as you've actually served the correct Section 21 notice, abided by all the technical guidance, so you're satisfied that you've actually given them the EPC before the tenancy started, gas safety certificates all were present and correct, they've had the how to rent checklist, everything was all served correctly, you gave them 2 month notice, you can prove you served them, it's an assured short tenancy, there's nothing else there, you would at the moment be able to go under the accelerated procedure, which is an N5B claim form, which is quite a long form, but you can get through it. And what happens at the moment is they are issued, they go to the judge looks through them as part of their box work. That's not a hearing, so they'll rubber stamp them essentially and then send the papers back to you. You then request your possession order. It's very, well, in theory, very straightforward. That will all fall away. There will be no more possession claims dealt with on the papers, essentially following the abolition of Section 21. It also means for landlords, if you're not used to using, or if you haven't used grounds before, even for rent arrears cases, because there are advantages to using grounds for rent arrears, especially because with the accelerated procedure, you can't actually seek money judgment. So there are definitely advantages to using the paper grounds. The paper route to court and a Section 8 notice of seeking possession, relying on current 8, 10 and 11 grounds, being that you can seek rent arrears and ongoing payment of any outstanding rent at the date of the hearing. So if you're not used to doing that, then it's going to be a bit of a culture shock potentially. But basically, it's all about evidence gathering. It's all about good record keeping of what's been going on during the tenancy, so that say you are issuing a claim on rent grounds, that you have good records of what you've been doing on the maintenance side, so you don't get basically sidelined by a potential disrepair claim at that first hearing. Equally, if there's antisocial behaviour or breach, that you've got a good evidence of what that was. So you would be pleading that, you'd be putting that into your particulars of claim as to why you're seeking the claim. You would be doing witness evidence, you'd be doing statements, and because you may well be asked about that at court, because you'll have to prove it, you'll have to show that there was antisocial behaviour or serious antisocial behaviour, or whatever ground you're relying on. You will need to make sure you've got the paperwork there. So it's all about good record keeping of what's going on, monitoring your tenants, and making sure you keep on top of everything you need to be doing as a good landlord. Okay, right, so now abolition of rent increase clauses, and also I've just mentioned other clauses because there's a couple of other sort of niche clauses which were mentioned in the white paper, which probably aren't applicable to most sensible landlords these days anyway, but they're worth mentioning. So contractual rent increases, as I say, in all of the previous consultations on this before this was coming, was never mentioned, and then the white paper came out and suddenly it's in there. So interesting politically, clearly designed to try and be a bit of a vote winner for tenants or for the general public, who unfortunately tend to perhaps view landlords as the baddies crudely and tenants as the goodies. So I suspect this was put in as a bit of a bung potentially. We'll see if it comes through, because I don't think it's been necessarily thought through very clearly by those putting the white paper together. But essentially, the idea is that any kind of automatic contractual rent clauses are to be abolished. That if there's something in your tenancy agreement at the moment that is called rent increase clause, it will fall away. It won't be usable once the second implementation date has come into play. Behind that, they want everyone to start using Section 13 notices, which are the statutory rent increase notices if you haven't used them and aren't aware of them. But Section 13 Housing Act 1988, if you Google Section 13, Section 14, you'll find the relevant form that you have to fill in. It's quite technical. There's some detailed guidance notes which are worth having a look through. But essentially, you can't increase rent more than once a year. Rather than giving a month's notice, you will need to give a couple of months' notice. They've also said they want to improve tenants' rights to challenge rent increases to the first tier tribunal. They haven't gone into any detail about what they mean by that, but I do know that at the moment the way to challenge your rent to the first tier tribunal would only be if it's at market rent and you saying you're being charged above market rent. So there's a bit of a risk to tenants at the moment, because actually if they're being charged below market rent, the FTT says it's actually this level and above what they're being charged. Doesn't mean the landlord has to go outside what they're charging already, and they really probably shouldn't as a matter of course, but it's not necessarily the helpful process that it perhaps should be for tenants to challenge their rent increases. Other things to or other changes. Okay, so this is actually quite a major thing, and it's actually more about the tenancy status itself. So there's not going to be any such thing as a fixed term tenancy. All tenancies will become periodic once this is fully implemented, this act or the bill, if it comes into play as it's currently envisaged. And that's the idea of that is to give tenants maximum flexibility. It will simplify the system, no doubt. So it will make life a bit easier, both sides, because you will know exactly what's expected of you as a landlord as well, if it's all done on a periodic basis. I mean, I suppose the benefit for fixed terms previously was that it was supposed to give tenants and landlords a bit of comfort. They wouldn't be looking at this again in for another couple of years, but actually the way it's been drafted, it is only periodic assured tenancies will exist once this act's fully implemented. So they will be abolishing any clauses that stop you letting to people on benefits, which I'm sure you don't have in your tenancy agreements, but anything like that will become unlawful, or to letting to families, people with children, anything like that, clearly not particularly fair or attractive in a contractual tenancy, and they will be abolished essentially. Also, no blanket ban on pets. So you can have conditional pet clauses, and in fact there's one you can find on the gov.uk website under the model tenancy agreement. They've actually already drafted something which you can look at and perhaps incorporate into your tenancy agreements ahead of any other changes being made. So implementation dates, as I mentioned it originally in the white paper, it stated essentially they wanted everything in place before the end of the parliamentary session, so the end of May 2023. I'd say that probably doesn't seem that likely at the moment, just because everything's at a bit of a standstill. Certainly nothing seems to be happening much on the levelling up side. But we should be given, basically the format of the implementation is set out in the white paper, which is that you should be given at least 6 months notice of the first implementation date. And the first implementation date, from that point, all tenancies should be periodic. They'll all be governed by the new rules, i.e. the grounds will apply as per whatever's stated in the white paper, whatever changes it makes to the Housing Act 1988 Schedule 2. Then at least 12 months after that, there'll be a second implementation date, and that basically will change any existing tenancies you may have retrospectively, so they're all periodic, and that any clauses in there that aren't allowed will be discounted essentially, and the new grounds should apply to those tenancies also. Okay, so that's the grounds and section 21 and implementation. So I'm just going to quickly talk about the Decent Home Standards, local authority enforcement measures, and the Ombudsman, private rented sector Ombudsman as proposed by the white paper. So Decent Home Standards, it's been something that's been in existence for social landlords for many years. I'm sure the properties you let out are already fine. They already abide by the Decent Home Standards, but essentially the idea is to introduce it into the private rented sector. Essentially, your home's got to be free from all serious health and safety hazards, fall risks, fire risks, carbon monoxide poisoning. So if you have any, I don't know, staircases without banisters, you might want to look at rectifying that now and getting ahead of yourself a little bit. Kitchens and bathrooms need to be adequate. They don't need to be fashionable or high end, but they do need to be adequate and fit for use. You should have decent noise insulation, clean, appropriate, usable facilities, warm and dry. Very important these days. And the government is going to review the housing health and safety rating system, which is the way that at the moment it enforces any kind of hazards, or local authorities use to enforce any hazards on the other side of things, for statutory nuisance purposes, for example. Now, it's worth flagging because actually, as you will see highlighted, there is a consultation about introducing the Decent Home Standards into the private rented sector. So if you Google that, Decent Home Standards consultation, it should bring you to the page on the gov.uk website. And if you're interested and you have time, then I would certainly put any views you have into place, because obviously that's the only way it's going to be noted. So it's the 14th, which is this Friday, I think, 11:45 p.m. Get your views in there as private landlords. I'm sure the government will be quite happy to hear from you. So the private rented ombudsman. So at the moment there is a housing ombudsman, but it only governs social landlords. So you can join voluntarily, but whether you do or not, whether you have the time to do that is another matter. But the government's proposing now to introduce a private rented ombudsman. And the idea behind that is hopefully partly to introduce some kind of complaints procedures so that your disputes can be satisfied by the Ombudsman without having to go to the county court. There's also discussion about a mandatory register of landlords and agents. Not quite sure who's going to keep that, local authorities or the Ombudsman, but you would be obliged to register as a private landlord, so they can, say, keep an eye on you, make sure you're doing what you need to be doing. They also want to introduce stronger enforcement powers for local authorities where there are breaches, so stronger powers for banning orders, that kind of thing. Quite helpfully, potentially, hopefully helpfully, they are looking to introduce something called a property portal to help landlords understand and comply with their responsibilities. So this would be a single place you could go to as a private landlord and see all the information that you need about all of your obligations, contractual and so on. I can foresee that being actually quite useful. So I know for things like HMO licensing, if you fall foul of that, if you're not aware there's a selective licensing regime, then actually if something like the property portal, you can do a search and find out where your properties are, if they're subject to anything like that. That could be potentially quite useful for you. But obviously, if you disagree, let me know. Okay, and I've got a final couple of slides about court reform. If you have any questions, do use the Q&A button at the top or bottom of your screen, and you can basically put in a question and then Theo and I can come to it when we get to my questions at the end. And you just type it in and we will get to it in a little while. Okay, so court reform. Okay, so there's no new housing court. This has been talked about on and off for years and years. The government's looked at it. They think actually the expertise is there. District judges know the law. They understand housing cases. They understand possession claims. So there's no need for a separate housing court. The government states that it's hopeful that the new private renters ombudsman should free up time for courts to deal with more serious cases. Potentially that could be the case, certainly for things like there's disputes over repairs, for example. It's not really sensible at the moment for it to go to the courts. It would be better if an ombudsman could use that kind of, or could be used for that kind of dispute. They're also talking about possession reform to digitalise processes. They have stated within that work is underway and it's due to be completed in 2023. I know they have PCOL at the moment, so possession claims online can be used for rent claims. Whether it's an expansion of that or not, it's very unclear. What difference it will make in reality is not clear. I do know that my clients who use PCOL do get their dates more quickly than just relying on the paper system. So potentially there is a slightly more automation built in, so it's not necessarily relying on some poor listings officers to be going through the box of all the claims that come in every day. They're also, and this should be welcome to anyone who's looking to enforce any kind of possession claim, the Ministry of Justice and court systems are looking at bailiffs' capacity, how to reduce administration to focus on enforcement, improvements to recruitment and retention. So essentially getting more bailiffs to enforce the possession orders that landlords do manage to get through the system. They're also talking about prioritisation of cases. So those cases that are listed as urgent, is there a way to split off ones where there's, for example, serious harm and expedition? Just to note that actually you can apply to expedite possession claims now if there were serious harm. If you had a tenant who was causing, serious nuisance or significant risk of harm, violence towards other residents, then you could make an application to expedite your possession claim anyway. It doesn't mean much, it just means you might get your first hearing in order, but it's worth looking at potentially. There's discussion about specialist property cases, split jurisdiction. So these would be things like service charge disputes at the moment where it tends to bounce between the first tier tribunal and county court or vice versa. Getting those dealt with in a different way. Improving provision of earlier access to legal advice for renters. So they tried that a little bit with the coronavirus pandemic. They gave numbers for duty advisors when the papers were sent off. Not sure how much it was taken up, but there's certainly facilities there. And alternative dispute resolution and mediation also looked at. So this is what's talked about. It's all a little bit airy-fairy. In reality, the problems with the courts are mainly due to resourcing. There's just not enough judges, there's not enough court officers, there's not enough courts to get these cases dealt with, and there's massive backlog still, even before coronavirus. So they all do take a while. And in my view, obviously, maybe it won't be like this, but actually if you're taking away the accelerated route as well, where currently landlords can get possession through the papers and through a judge looking at those cases at the end of the day, that's potentially 10 extra cases that should be heard with a court hearing that have to be factored in. So it's all very well and good, but if the government is serious about court reform, then they're going to have to look at how they fund the system. And the current government's not particularly interested in expanding the state. So I'm not sure how much of a list on their priorities it's going to be. Okay, and then I think I've got a question slide, but I think Theo, you've got something more to say now before we go on to a Q&A.
Yeah, thank you for that, Anna. I think worthy of the title Masterclass, certainly very in depth.
Thank you, thank you. Right,
I'll share my screen. I've just got.
Shall I stop? I'm just going to stop my share, and then hopefully it'll come on to you.
Yeah, should work. Fantastic. Okay, great. So you've heard all the details. So I'm just going to kind of quickly run through what the BPF has been up to in terms of trying to enhance the changes and kind of push back on some of the issues. So I won't go into too much detail on the actual changes themselves, as Anna has done so thoroughly. But obviously, there's kind of these key areas that will impact our sector as you know, large professional landlords, and obviously some of the changes, you know, we've been expecting for a long time. You know, we've been working closely with government on. There's things that we'd like to see come. I mean, for one, the new property portal, I think, is something that the BPF has been calling for a good 15 years. So long before my time, but yeah, we're finally seeing that realised. There's also obviously court reform, which Anna mentioned. You know, it all sounds positive in the right direction, but I think the fundamentals, you know, remain with resourcing and the like. And of course, decent home standards, which we think most members should be able to kind of get on board with from day one and exceed. Obviously, the end of Section 21 has been kind of on the cards for a long time, and it's just about kind of managing that and delivering that in the best way possible. But there was obviously, as mentioned, a lot of surprise, because during the consultation process, there was no mention of rental review clauses being scrapped. And this is obviously somewhat in reaction to the cost of living crisis. You know, very often they're tied to inflation, tied to CPI. So I think it's seen as a bit of a short-term easy win. So I'll just kind of go on to the key areas that we're still focusing on and still looking to make change and progress on. So obviously the rental review clauses has kind of come out of nowhere, and we think, you know, it's a bit of a nuclear option for quite a short-term problem. Obviously in today's kind of inflationary pressures, such a rise in line with inflation can seem from the outside as unacceptable to government, and it's a bit of a winner for the public. But what we have to understand is that these reforms need to stand the test of time. So we could be looking at 10, 20, maybe 30 years until we get this generational chance to reform the system. So we are pushing to maintain the rental review clauses in some form, and we've conducted some strong arguments on the case. Mainly the fact that, you know, it's quite obvious that, you know, mortgages are obviously tied to reviews in a similar way. It's used by government itself. It's used in social housing. there's various measures you can do to impact and alter the changes so they're not crippling the tenant in any way. The key thing is really it's policy being made on this particular moment, and we think that they're a perfectly reasonable measure to be used in the future. So obviously it avoids a lot of headaches, particularly when you're working across huge portfolios and large portfolios, which many of our members are, avoiding the headache and really quite egregious use of Section 30s, Section 13s, which will take a lot of time and create a lot of pressure for larger institutional landlords. So that's something that we've really been pressing on, and our members have obviously been asking for. Now, the property portal, or the sort of landlord register, is something we've obviously been asking for a long time, but in the way that it's been delivered, there hasn't really been much information so far, and in our talks with civil servants, we are kind of looking to enhance its delivery. So we think there's a chance to make it a bit more than a box ticking exercise and have a bit more value, to really force out rogue operators. I mean, the argument against it has always been, why would, rogue operators sign up for the portal? They'll kind of stay underground anyway. So we're looking to put forward a claim for, it's been called in the past the unique property reference numbers. So it'll be tied into accessing finance, tied into accessing housing benefit for tenants, tied into all manner of things, access to the courts. So it really would make life incredibly difficult not to have a unique property reference number. So we're pushing for changes to make it a bit more kind of stringent and effective, rather than just an added layer of bureaucracy. So as mentioned, the court reforms, all the outlines within the response to the court reform consultation, they seem to be heading in the right direction, but what we need to see is them actually in place and working. I mean, we've already got backlogs with cases from some members where with up to a year for possession for severe cases of antisocial behaviour. And I think there's an understanding amongst government, certainly amongst parliamentarians, of the huge issues with the courts. So I think hopefully we'll see some more movement on it. Our main asks here are quite detailed on how this could be applied, so I won't get into that, but essentially we need the courts to be seen to be working, to be basically ready to go, and actually be able to cope with the potentially increased pressures. Obviously, with the new Ombudsman and mandatory redress scheme, they're hoping to avoid some pressure on the courts, but I still think massive reform is needed there, and resourcing. One of our asks that's kind of coming from the reforms, it's not directly mentioned, is an attempt to rein in selective licensing. So for many of our large operators in areas with selective license, blanket selective licensing, these tend to be areas kind of in need of regeneration, some areas with lower socio-economic margins. So we're essentially saying that with the addition of, we've got the new property portal, we've got the new mandatory redress, we've got the new ombudsman, we've got the decent home standards, you've got this whole slew of new regulation. It kind of begs the question, how effective is selective licensing, and won't all these changes replace it and be able to at least offer central government some comfort in knowing that they're correctly regulating the sector without an extra, very expensive and burdensome requirement. So we are looking to kind of press on with reining in of selective licensing in certain circumstances, particularly for student accommodation. So that was an actual recommendation from the 2019 RUG review of selective licensing. So I think, yeah, we're basically pushing a campaign there. So I think one of the issues obviously is there's going to be a new mandatory redress scheme, and we want it to be competitively priced. So many of our members are obviously part of the voluntary redress and use the ombudsman, the PRS ombudsman. The housing ombudsman currently. So we just want to make sure that that's aligned and offers a valuable value for money service. Finally, on Section 21 itself, it's currently within a periodic tenancy. There'll be a chance for as a sort of 2-month notice for tenants to leave. There are some concerns amongst the sector that this could lead to issues of, particularly in hotspot areas like London and Manchester, of sort of short-term letting scenarios where tenants kind of only are looking to get the initial 2-month period. So we were looking hopefully for a notice period of an option for 4 months for tenants to be able to give notice into a new periodic tenancies with a 2-month notice, so a total of 6 months. And I think that's been kind of backed up by the experience they've had in Scotland. I've heard that it's been one of the things that they wish they could have changed would be to have a bit of an increased notice period and that to work a bit better. So I think we've got some strong evidence there. But those are the kind of key areas that we've been engaging on, and the way that we've been doing that I'll detail next. So a lot of our work has been ongoing this summer, as when we met with DLUC officials, they were really key in stressing that a lot of the policy making was going to be happening over the summer. So we met with outgoing ministers, and we of course attended a very valuable roundtable with Eddie Hughes. We also have begun an engagement with new ministers, which has been hopefully really valuable. One of the things I'll say is that given there's a sort of new government and a whole host of new ministers and undersecretaries, there's really a chance for us to re-engage on this, and I think there might be a bit of a change in direction potentially. I mean, certainly one of the issues is that given the government's got such a sort of a tight 2-year window to deliver so much policy change, it seems unlikely that they'll make any radical shifts from the commitments they've already outlined. But I think there is a chance to affect change and make sure it's delivered in the correct way. So we've been very active on that front. We recently delivered evidence to the Levelling Up the Housing Community Select Committee. So we delivered written evidence, but then we were invited to give oral evidence in September, which I really think the parliamentarians there understood the issues we were raising. We have obviously, some allied stakeholders as well in the NLRA, which were there and contributing. And I think there was understanding, particularly on court reform, of how important it was, because day to day, many of them are experiencing with their casework, the ongoing issues of antisocial behaviour and the difficulty it is to get through that court system. A lot of work has been done with the civil servants themselves. So for each area that I've outlined, there's essentially a separate team kind of working on that. So we've met with all those teams and inputted our thoughts and have an ongoing discussion with many of them, particularly on rental reviews. We've had several meetings and are looking to kind of have a collaborative relationship, particularly on the property portal and how that will be actualized. We've also are going to kick off a bit of a media campaign, particularly on some thought leadership on selective licensing and how rental review clauses will work. And we are also have created a briefing for lobbying of parliamentarians and MPs themselves, which we're hoping to kick off shortly. So I think that'll be important in generating some sympathetic views on that side. So I think that's sort of a quick run through of everything we've been up to. It's a bit difficult, the next slide, on sort of looking ahead. And as I mentioned, having a new government offers a really good chance for some fresh engagement, which we've been taking full advantage of. But like I said, it's quite difficult to see them shifting on some of the larger headline pieces. I mean, particularly the loss of Section 21, I think, obviously will be maintained. But I think in some of the smaller, perhaps less thought out changes, maybe we can get some sway on. Given a bit of radio silence and given such a busy parliamentary schedule, I'd imagine, and I've been talking with officials, although we can't take this with any real authority, but I imagine towards late 2023 as a likely time for the rental reform bill to come, perhaps a little bit earlier, but there are obviously a lot of pressures on parliamentary time, and it's quite difficult to gauge exactly where things are headed. But yeah, it's certainly gone a bit quiet on this front, but we're obviously continuing engagement in the background. So I think that sort of concludes both our masterclass and our sort of BPF perspective. What I'll move on to next is a bit of a chance of a Q&A. And I'll just welcome any questions from the audience. I think the first thing that we'll do.
Theo, do you want me to answer a couple of the questions? Because
Yeah,
the one at the top I know.
Yeah, I think
okay.
all of those are pretty much there for you to knock out the park. So
a couple of them are a bit legal.
Yeah, exactly.
So the first question is, does this new reform affect contracts with over rents of £100,000 as well as ASTs? So this is high rental tenancies, and under the Housing Act 1988, they are excluded from the regime at the moment. So that used to be anything over £25,000 was excluded and would be a contractual tenancy because it was considered a high rent tenancy. But these days it is actually over £100,000. The way it's drafted, no, this should only affect assured tenancies. So talking about the grounds, it's talking about Section 21, it's talking about Section 13. So it's all about the existing tenancies. And the whole point of contractual tenancies, when they're that high value, is that you can get possession by serving a notice to quit, essentially, and you don't have to prove your grounds, because it's such high value. If you're going to start losing money, you're going to lose money quite fast if people refuse to pay. So that's the idea behind having them. And also on the other side, really low value tenancies are also outside the system. So at the moment, the way it's drafted, no, but obviously if they're looking at the tenancy as a whole, they might well be looking at the parameters, but possibly they'll push the parameters upwards from the 100,000, even higher potentially, so that more tenancies are captured. But it's speculation. At the moment, the way it's drafted, no. Theo, do you want to take the timeline for phasing these in, because I think you have a bit more insight than me.
Yeah, I can address that, but not with any real authority, because the crystal ball is a bit murky at the moment. But given parliamentary time, we're looking at hopefully late 2023, and then there would be a period of adoption. So Anna, I think you mentioned in your slides that there'd be an initial 12-month changeover. We're obviously pushing for something a little bit longer. I think we positioned ourselves closer to the 18th month mark, maybe a bit longer, and particularly hinging on certain things. So like I mentioned, court systems being in place and working, reforms in other areas coming through, the residential portal being up and running, which at the moment, from what I've seen, is very early stages. So it's a little bit of a tricky one, because I think government themselves are a bit unsure on that one. But I think they are looking to phase things in and being quite generous. Hopefully we'll be looking to be a bit more generous with the time that they've scheduled in. So that's what we're looking at.
The way I've read the implementation dates in the white paper itself is that we will get at least 6 months notice before any new tenancies have to comply with the regime. So that's just the contractual terms. That doesn't affect court reform or anything else. It's not everything on the list, but in terms of what happens with your contracts and your tenancies and turning them all from fixed to periodic, essentially oh, what's it? So it's 6 months for new tenancies, and then a further at least 12 months for any existing tenancies, at least. But it will probably be longer than that. I'll take the next one, Theo. So basically, new periodic tenancies does this really mean that new periodic tenancies could actually be for life, given the limited grounds for possession? No, I wouldn't say that, because you do have mandatory grounds which don't necessarily relate to the tenant's conduct. So there will be ways of getting possession in the right circumstances. But that said, if there isn't the right circumstances, or the right circumstances don't arise, then potentially they could carry on. But so potentially, yeah, they could carry on for life. You could have a tenant there, and obviously, if they're a good tenant, then that may not be a bad thing. You've got a consistent rent coming in. They're a good tenant. They're looking after your property, and vice versa. But yes, essentially, they're assured what we call in the social sector assured lifetime tenancies, because if Section 21's gone, there's no fault grounds, then they could live there for long. The idea is behind it to give people more security of tenure in the private sector. So I think that's the aim behind it. But equally, you will always be able to seek possession. So there will normally be a reason that you can seek possession. So if you're looking to sell the property, for example, the grounds are there, they're mandatory grounds. So that should hopefully give you a bit more comfort.
Yes, yeah, I just chime in. One of the concerns, obviously, for some of our larger build-to-rent operators is about refurbishment, and that is a ground. So, within a lifetime, you want to obviously see an entire block refurbished and renovated to keep up with the time. So obviously that maintains and remains as a ground, and I think is a bit modified from the originals. So
well, yeah, it would be good to modify it a bit, because at the moment the way it's drafted is terrible, honestly. So
yeah,
hopefully they'll make it a bit easier to use.
Yeah, from a legal perspective, it's the intent is there, if I'm right in saying, but the way it's currently drafted leaves a little bit to be desired. But from our conversations with the sort of ground reformed team, I feel quietly confident that they understand that the need for refurbishment, particularly in the age of retrofit and net zero, that those grounds will be kind of made and retained. So yeah, I'm confident that they kind of won't be full lifetime, but if they are, I think maybe that plays into a property owner's favor. Thank you for that. We've had one more question, just a quick one on a bit of housekeeping about where the recording will be. So we normally put them up onto our BPF YouTube channel, so that hopefully that will be available in the next few days. I believe, Anna, that you're also willing to share the slides afterwards.
I'll be sending the slides. Yeah.
So that's all good. We've got another question coming in here, Anna. I think this potentially for you.
I don't know the answer to this one. So it's the first question is, if all tenancies are periodic, are you still able to take rent in advance for a certain period for cases where the resident doesn't pass referencing to pay monthly? I don't think you will be able to, but I'm not 100% sure. So I don't think I have the answer to that. Theo,
I haven't got the answer for that, and I haven't actually had that come up in discussion. So that's actually a really interesting one that I can take forward.
I suspect that's more about deposits potentially. You can still, they're looking at the deposit protection scheme as well, but it's more in the technical side. So you should still be able to take deposits, but not rent in advance. I'm not sure is going to be a thing anymore, potentially. I don't know the answer. In fact, I'm just going to show.
I'll have to double check. Potentially some of our kind of allied stakeholders might have asked this question, because it's more common, I think, in the kind of the wider PRS. So I think maybe the NRLA might have the answer. So I'll have an ask about that. But thank you for that question.
I think maybe one last question, Theo. There's a minimum term for mandatory periodic tenancies. Will it remain as 6 months as per the AST? It's not clear. The way the government's said is it's only periodic tenancies, so I'm not sure about how the minimum period will expand. Although, hang on, there was mention of not using grounds within the first 6. Yes, so actually So it won't be there, but there's certain grounds you can't use in the first 6 months. So there won't be a minimum term. It'll all be periodic, but you won't be able to rely on certain grounds if you wanted to. So for example, if you wanted to substantially redevelop the property, that's listed as one you're not going to be able to use within the first 6 months. The reasoning being, presumably, that you shouldn't be letting out properties if you think you're about to redevelop them anyway.
And I'll take one final question that I know some of the answer to. So during the consultation period, was there any discussion or points raised on the principle of tenant passports? So I think that's to do with sort of the lifetime deposits. So that has been kind of an ongoing debate and question that we raised. You know, we're kind of in favour with that. But at this point, with the technicalities of how that would be worked out, it wasn't taken forward by government. Having said that, I think they're still looking to kind of reform some of the work around the TDS and how that will play out. So I won't expect that idea to go away as a policy piece, but it hasn't been picked up by government as of yet, which is a little bit disappointing, but yeah, something we'll continue to raise. I think that will just about wrap it up.
Yeah, I think we're nearly at 12:30. Thank you, Theo.
And I'll just give my sincere thank you to Anna for joining us today. I think a really helpful kind of preliminary deep dive into these changes, which obviously, you know, haven't taken effect yet, but it's really important that, you know, our membership are informed on it and are ready to adapt to these coming changes. So I'm not sure if there's anything else you'd like to add, Anna?
No, not really. The only thing I'd say is perhaps have a look at your tenancies as they currently stand and have a little look at where the points are. And as I say, there is a very useful document, if you not just the white paper, but the New Deal for Renting Government Response has quite a lot more detail than the white paper does, obviously with the caveat that this is how it was envisaged in June and there may well be changes before any eventual implementation.
Thanks, Anna. And of course, any questions outside of this, I'll be sharing my contact details and potentially those of Devonshire's for any more technical questions. So yeah, only leaves me to wish you a happy Monday and a great rest of the week. And thank you so much for joining us again. And yeah, we'll be continuing to work in this area, of course, and hopefully be doing some more events closer to the sort of launching time. So thank you very much for joining us, and I'll end it there. Thanks all.